Good afternoon and welcome to the third and final webinar in our confidential information series. Before we start the webinar, we have a few small housekeeping points to go through. Firstly, to keep background noise down, we've placed each of you on mute. There will be an opportunity to ask questions at the end, but you can also use the chat function throughout the presentation to post any questions you might have, and we'll pick them up at the end as well. As I mentioned, this is the third webinar in our series focusing on confidential information. This is part of a wider series of webinars from the commercial litigation team. The next webinars in the series will look at developments in contract and intellectual property law in 2016, and webinars from previous series are available if you follow the link that's shown on screen. Your speakers today are John Mackenzie and me, Matt Phillip. John and I work in the commercial disputes team, and we regularly advise clients about confidential information in contracts, including advising on different legal action that can be taken to prevent the use of confidential information if it falls into the wrong hands. And that's what we're going to speak about today. We're going to look at the steps that should be taken to prevent misuse of confidential information that's been obtained by a competitor, and the format of the webinar is shown on screen. We'll start by recapping the last seminar, looking at the ways in which a business can maintain the necessary quality of confidence that information must have to benefit from legal protection. We'll then look at what evidence is required to prove that confidential information has been transferred and the different ways to go about getting that information. At the outset of any dispute about alleged misuse of confidential information, it's important to consider the evidence that you have and identify any areas of weakness in your potential claim. In some cases, preventing the misuse will be the priority. However, in others, it will be more sensible to take steps to try to recover and preserve potential evidence before then taking the steps to prevent misuse. We'll then go on to speak about the legal remedies that are available to prevent misuse of confidential information. The remedies can be split broadly into civil remedies and criminal proceedings, and we'll touch on both of those. Civil remedies include the use of undertakings by the parties, either to each other or alternatively undertakings to the court, injunctions or interdicts, and also damages for loss suffered. There are also a number of criminal sanctions that can be imposed when a party misuses confidential information. Today we're going to look at 3 statutory offences contained in the Computer Misuse Act 1998, the Data Protection Act 1998, and the Bribery Act 2010. We'll then look at when these remedies are available and how to decide which remedy is effective and appropriate in the circumstances. And then we'll conclude the series by recapping some of the key points that we've looked at in the series as a whole when thinking about your information, whether it's confidential and how best to go about protecting it.
So far in the series, we've looked at identifying and maintaining the necessary quality of confidence of information. As previously mentioned, this is important because as soon as that quality is lost, legal protection becomes more difficult. For example, there's a significant difference in the protection afforded to trade secrets when compared to mere confidential information, particularly when considering whether protection survives termination of an employment relationship. We also looked at the duties owed by employees when they're passed confidential information by their employer. The general duty owed to the employer is one of honesty and good faith. In this context, it means not making a profit from or otherwise misusing the employer's confidential information. We'd also looked at how an employer can make it clear that information is considered to be confidential. This includes restricting access and marking documents to make this clear. In terms of keeping information secure, electronic passwords on computers and files and locked cabinets for hard copy materials will always help to reduce the risk of unauthorized disclosure. But even with effective policies and procedures in place, information can be taken and misused. Often it might not be clear whether the information has been used for unauthorized purposes and, if so, who is responsible, how it was obtained, and what has been done with it. For this reason, an important first step is often to investigate further so that these questions can be answered. We're now going to look at some of the different ways to find out more about what has happened.
These days, it's increasingly likely that confidential information will be created, stored, and then sent electronically. Documents stored electronically create risk because they can be transmitted more easily and circulated more widely than hard copy documents. Where it's suspected that an electronic document has been misused, the first step is to understand the source of the document. In the last webinar, we spoke about ensuring IT policies and technology are put in place to enable monitoring of employees' use of email and other devices. Of course, the flip side with the ease of which documents can be transmitted is that they can also be logged more accurately, and this makes recovery of evidence more likely. Large volumes of data can also be searched relatively quickly to identify relevant information, and in the last few years, electronic document review platforms have become increasingly sophisticated and cost-effective. Vast amounts of data can be retrieved from an individual computer or from a network, even where attempts have been made to conceal the actions that have been taken when the information was misappropriated. This type of investigation can be conducted internally, though this normally depends on the skill set of the IT teams within the business. And if a large volume of data needs to be reviewed, or if the data reviewed is in multiple formats, like audio files or images, it can often be more efficient to instruct an external forensic IT firm who are able to deal with these challenges. The ability to recover information that's been deleted or corrupted often surprises people. There are examples of hard drives being recovered from burnt-out buildings and reconstructed for use in court actions. In addition to looking at emails sent, downloaded files and other electronic actions, the investigator can also review print logs to see what documents have been printed and when, so that the information, if it's taken in hard copy, can also be evidenced. But these types of review will only be effective where the evidence required is already in your possession. Often a party will have good grounds to suspect that confidential information is being misused by a third party. However, in order to prove this, they need to recover evidence from them. There is also often a concern that if the third party is informed of this, then they will take steps to destroy or conceal the evidence. In these circumstances, it's possible to apply to the court and obtain permission to conduct what is commonly referred to as a dawn raid to recover evidence. The recovery of evidence in this way is governed by sections 33 and 34 of the Senior Courts Act 1981 in England and Wales, and section 1 of the Administration of Justice Scotland Act 1972 in Scotland. The English process has developed from the case of Antoine Pillar shown on the slide, and for an order to be granted, the claimant must show, firstly, that they have an extremely strong prima facie case, second, that the respondent's actions have resulted in very serious potential or actual harm to the claimant, and third, that there's clear evidence that incriminating documents are in the respondent's possession and there's a real possibility that they might be destroyed if notice was given. The test in Scotland isn't quite as high. In Ted Jacobs Engineering and Robert Matthew, it was described as a prima facie, intelligible and stateable case. The general process, however, is similar in both jurisdictions. An independent party is appointed by the court to perform the search. In England, this will be a solicitor who acts as the supervising solicitor, and in Scotland it will normally be an advocate who takes the role of commissioner. They will be authorised to attend a particular location and search for documents that fall within a specific category that's been approved by the court. The supervising solicitor or commissioner then prepares a report of the search and the documents recovered. In England, the documents are then made available for the claimant to use in their claim straight away, and in Scotland the documents are consigned with the court to await a further order. We don't really have time to go into the specifics of dawn raids today. However, they can serve as a very useful tool as they enable the recovery of documents to support a claim before the action is actually raised. If they didn't exist, it might not be possible to obtain that information, which could frustrate an otherwise good claim. As they're granted without adherence, however, and they are described as a draconian order, the courts will scrutinise the claimant's position very carefully to ensure that the scope of the order is appropriate. In both jurisdictions, the claimant is also required to provide undertakings that they will indemnify the third party for any loss that's suffered as a result of the search.
That reference to undertakings leads us nicely into the next area for discussion today, which is the remedies available. When you've recovered evidence demonstrating that the information has been misused, the next step is deciding what action should be taken. There are a wide range of measures that can be taken to try and stop misuse. The first step that can be taken is to ask for undertakings. Normally, undertakings will either be given before an action is commenced or after the action has been raised as an alternative to interim orders being granted. Undertakings are probably the simplest step that can be taken to protect confidential information. An undertaking is given by the party who has unauthorised access to the information and will state that they undertake not to use the confidential information. In addition to an undertaking not to use the information that's been obtained, the document can include a number of other provisions or undertakings. For example, that the information will be permanently deleted, or to disclose any use that's been made of the information during the time it was in the party's possession, or to allow an IT expert to review the party's systems to confirm that the information was in fact deleted and that no other confidential information was taken. The willingness of both parties to agree to undertakings will depend on the circumstances. The party providing the undertaking is often being asked to agree to what can be wide-ranging and invasive provisions that will have a significant impact on their business. On the other hand, the party receiving the undertaking may be justifiably distrustful that the undertakings will be complied with, given the other party's misuse of their information. However, if undertakings are not agreed, then normally the only alternative is court action. As we'll come on to discuss, litigation almost inevitably results in an increase in time spent and cost. There are also reputational considerations for both parties. One has misused the information and the other may not have kept it under control in the first place. In our experience, offering and agreeing undertakings at the outset can be a very useful way to bring parties back from the brink of litigation. As a potential defendant, it will normally be in your interest to try and delay immediate action being taken against you. If information has been used inadvertently or unsure as to your position, this buys time to better understand the claim being made. By agreeing to carefully worded undertakings, you can investigate what has happened to understand the extent of any potential liability. Even if the dispute cannot be completely resolved, it means that when proceedings are brought, you are in a position to properly defend them. If you are the potential claimant, it is important to remember that, particularly in cases related to misuse of confidential information, there is a significant upfront cost involved if a claim is raised. This is because there will often be applications for interim orders and document recovery. Even if you are ultimately successful, you will only recover some of this cost from the other side. This can make undertakings an attractive alternative to litigation. However, when considering their terms, it's wise to ensure you do not agree to waive claims in consideration of the undertakings that are given. This is more common under English law, where it's necessary to provide some consideration for the undertaking. However, it is important that rights to seek further relief from the court for injunction or interdict in Scotland or damages are preserved. Undertakings can also be offered after proceedings have been raised. This might be because the third party was not given notice of the claim against them, or because the terms of an undertaking cannot be agreed between the parties. It's still possible for contractual undertakings to be agreed between the parties at this stage. However, an undertaking can also be given by the defendant to the court. The main difference between an undertaking given to the court and a contractual undertaking is that there is immediate sanction for a breach of it. A breach is considered to be a contempt of court and can, in theory, carry a prison sentence. In contrast, the remedies for breach of a contractual undertaking are the same as in an ordinary breach of contract case.
If an undertaking not to use the information hasn't been offered or isn't accepted, the alternative is to seek a court order preventing use of the document in the short term. This is known as interim injunction in England and interim interdict in Scotland. The general effect of the order is the same in both jurisdictions. The court will order the defendant not to make use of the confidential information, and if they don't comply, then as John mentioned, they face quasi-criminal sanctions. Whilst the general effect is the same, the tests applied by the court in deciding whether to grant the order are different in each jurisdiction. In relation to interim injunction in England, the case of American Cyanamid Co. and Ethicom set out the criteria that the court must consider when deciding whether or not to use its discretion to make the order. The first point that they have to look at is whether there's a serious question to be tried, and this is a requirement for the party to demonstrate that there's a real prospect of succeeding in his claim. And then the second element is the balance of convenience test. If the parties demonstrated that there's a serious question to be tried and that damages would not be an appropriate remedy, which I'll come on to look at, the court will then consider where the balance of convenience lies. This involves considering a number of factors, including whether the order is in the interests of justice, the preference of the court to maintain the status quo, and whether more harm is likely to be done by granting or refusing the order. The third issue that the courts tend to deal with separately is adequacy of damages as a remedy at trial. This technically forms part of the assessment of the balance of convenience test, but is typically considered separately. If an award of damages at the trial or payment of an undertaking by the other party in advance of the trial would be considered to be an adequate remedy, then the court will normally refuse any application for interim injunction, regardless of how strong the party's claim appears. To obtain an order for interim interdict in Scotland, the party must satisfy the court that it has a prima facie case, which is the equivalent of the serious question to be tried test in England, and also that the balance of convenience favours making the order. There's generally less emphasis by the court on whether damages would be an adequate remedy, and even if damages could be claimed, the court will often be willing to grant the order if it can be shown that the balance of convenience favours this. One further difference in the approach that's taken by the Scottish and English courts is in relation to whether the application can be made without notice. In England, the court will normally expect notice to be given to the other party, even if that's at very short notice. No notice at all will normally only be acceptable where it would enable the third party to defeat the purpose of the injunction. In Scotland, it's much more common for interdict to be granted without notice to the other side. However, it is possible for an individual or a company to lodge what's called a caveat. This is a document that requires the court to contact the solicitor instructed for that entity if an application for an interim interdict is made. The solicitor can then take instructions and appear in court to oppose the application.
The English courts have also recognised a specific type of injunction called a springboard injunction. This is a remedy designed to prevent the former employee from using confidential information as a springboard to gain a head start with their new employer. The springboard injunction is unusual because, unlike most other forms of injunction, it isn't really about preventing a future legal wrong. The springboard injunction is seen as a way of preventing the former employee from gaining an unfair competitive advantage, and in that sense is more of a punitive measure of that for that person's conduct. A springboard injunction is temporary in nature and usually lasts for about 6 to 12 months. The length of the injunction will be approximate to the length of time a court considers it would have taken the former employee to gather the information lawfully without misusing the confidential information. A recent decision by the court in the case of UBS Wealth Management UK Limited and Vestra Wealth LLP indicates that the scope of springboard injunctions that are imposed by the court can be quite wide where the circumstances require it. The case considered a senior manager at UBS who left the company and formed a new business in competition with UBS. 75 UBS employees then left and joined a new company, Vestra. UBS were successful in obtaining a springboard injunction preventing Vestra from approaching any more UBS employees or from doing any business with UBS clients pending a full trial on the issues in dispute. The court held that a springboard injunction is available to prevent any future or further serious economic loss to a previous employer caused by former staff members taking unfair advantage, an unfair start, of any serious breaches of their contract of employment. Another example of how injunctions can be used in English law is to seek an order for delivery and destruction of confidential information. This was recently used in the case of Arthur JG UK Limited and others, and Skripchenko and others. Here the court ordered delivery up and inspection of computers and devices belonging to former employees and their new employer, and the destruction of any confidential information belonging to the former employer that was found on them. In this case, the order was actually made prior to the court's decision on the merits. In order to protect the defendant's position, the court also ordered that copies of the computer files be made prior to deletion and stored with the claimant's solicitor. That way, if the court determined the action was unnecessary, the information could be restored. However, the nature of such an order shows the flexibility that the courts can be willing to show when they feel that the defendant cannot be trusted not to use the information, and even that an interim injunction is not sufficient to prevent misuse. In deciding to make this order, the court also held that, given the likelihood that the employer would be able to establish a claim for breach of confidence at the trial, the order would involve the least risk of injustice if it turned out to be wrong.
The third and final set of civil remedies that we're going to look at today are financial claims, specifically claims for damages and an account of profits. The first issue to consider when looking at a claim for damages is the extent of the loss that's been suffered. It can be difficult to identify the loss with a high level of accuracy. One example of how a party might try to do this is by quantifying the value of the contracts that they believe were lost as a result of the information that's been used. Once that's been done, the next step is to try to determine whether that loss is actually recoverable from the party in breach. In the case of universal thermal sensors and Hibben, the court noted that there's no irrefutable presumption that business gained by a party following their misuse of confidential information derived from that wrongdoing. There can be many other reasons why a loss has been suffered, and this recognises a common defence that's used by the former employee, namely that the business would have been lost anyway, or the customer that I had would have followed me because of the good relationship I had with them. Disproving that defence can be very challenging. For those reasons and for others, quantifying the damage suffered can be very difficult, and as a result, the former employer can use the alternative claim for an account of profits. Rather than focusing on the damage that's been caused to the employer, the remedy looks at the former employee's profit as a result of their misuse of the information. An order can then be sought from the court requiring the former employee to pay the profit made over to the employer. It should be noted that both financial claims and an injunction or interdict can be brought in the same action. They're not exclusive remedies. But importantly, and as discussed earlier, in English law, if damages are an adequate remedy in the circumstances, then an injunction will not normally be granted. This is because injunctions are generally considered to be harsher and a more intrusive judicial instrument.
In addition to the civil remedies available, there are also criminal sanctions that may also apply to misuse of confidential information. The first example of criminal liability that we'll look at is contained in the Data Protection Act of 1998. If the confidential information contains personal data of the employer's staff or clients, then it could be a criminal offence in terms of Section 55 of that Act. The recent case of Mark Lloyd highlights the dangers involved. The Information Commissioner's Office brought the case against Mr. Lloyd, who was a former employee of Acorn Waste Management Limited. Mr. Lloyd emailed himself the personal details of 957 clients of his former employer that he intended to use in his new job. Mr. Lloyd pled guilty to unlawfully obtaining personal data under Section 55 of the Data Protection Act, was fined around £300 in fines plus costs, and has a criminal record. The second possible criminal offence applies where a third party provides some kind of inducement in return for the confidential information. Commonly referred to as a bribe, the Bribery Act 2010 imposes criminal liability on the person providing the inducement, the person receiving it, but also the employer if they do not have adequate policies and checks in place to ensure that their employees conduct themselves appropriately. This year, for the first time, an employer was fined £1.4 million for not taking active steps to prevent bribery, and that any measures that were in place were not sufficient to satisfy the requirements of the Act. The Bribery Act gives the court the power to fine companies up to 400% of the benefit gained through bribery. In addition to this, an employee who fails to comply with the Bribery Act can receive a custodial sentence of up to 10 years. The final potential criminal sanction to be aware of that we're going to cover in this webinar is the offence in the Computer Misuse Act of 1990. Section 1 of the Act makes it an offence if a person causes a computer to perform any function with intent to secure access to any program or data held in any computer. The offence occurs if a person intends to gain unauthorised access and knows that this is the case. Employees can also be guilty of the Section 1 offence if they use their computer at work to access any program or data that they are not authorised to access.
So, to conclude this series, we want to highlight some of the key issues to be aware of when it comes to protecting confidential information. The first, and possibly most important piece of advice, is to know what it is. That may seem self-evident, but it's often not until information has actually been misused that the value of it becomes clear. It's good practice to test internal processes and procedures and make sure that there's a system in place to recognise when information should not be shared out with the business, and also when it's so central to the operation of the company that it could be considered a trade secret. When you know what information you want to protect, the next step is to think about the best ways to achieve that protection. One of the best ways to prevent unauthorised disclosure is to carefully consider who should be given access to that information in the first place. When sending information by email, it's very easy to get into the habit of copying this to the full project team, and this creates two problems. Firstly, the more people that are given access, the greater the chances of eroding what's called the necessary quality of confidence that the information must have to be capable of legal protection. And second, the more people that are given access to it, the greater risk that it will be shared more widely or misused. Controls should be put in place to restrict access to the documents in electronic and hard copy format, and when they are confidential, this should be marked on the document. Finally, if your confidential information has been obtained and you suspect that it's being used, it's important to act quickly. The longer the delay, the less willing the courts will be to grant interim orders to protect your position, and the more likely it is that you'll suffer damage because of the misuse. If you act quickly to investigate and identify the scale of the issue, then it will increase the likelihood of a successful outcome. That concludes today's webinar and the series, and so there's now some time for you to ask questions. As I mentioned at the beginning, questions can be submitted by typing in the chat box. While you're doing that, I'll just also mention that there are a number of other webinar series being run by Shepherd and Wedderburn at the moment, including on property dispute resolution and construction law. And if you want to find out more about these or to catch up on previous series, the link to our webpage is shown on the screen now. Doesn't look like we have any questions at the moment, so if you do have any, then please feel free to pick up with John or I separately after the webinar. But all that remains is for us to thank you for attending today and for attending the series. Thank you.
Thank you.